Welcome to Real Equity. This is your go-to podcast for all things related to the expanding world of asset tokenization. Here is a quick overview before we go live with today's show. Rapid blockchain advancements are enabling real-world assets, like real estate, to be converted into digital tokens. This is reshaping the investment landscape and opening up new frontiers. We dig deep into how digital tokens are transforming asset liquidity and accessibility. However, this space is not without its complexities, especially when it comes to navigating the regulations. We tackle these issues by drawing insights from legal experts, technologists, and industry leaders. In this podcast, we explore the big developments shaping the industry, and we are not afraid to take on the difficult questions. Like, can regulators effectively respond to this shift? What does the future hold for asset tokenization when regulations are not clear? Or why is a real estate token considered a security? The recently announced SEC approval of the Bitcoin ETF is a landmark decision. But it is not just a win for cryptocurrency supporters. It is, without question, a harbinger of the potential for all tokenized assets. Join us now as we unravel the complexities and celebrate the triumphs in the world of asset tokenization. Stay tuned and enjoy.
I want to thank our guests for joining. As our intro to the show said, we are drawing from genuine industry experts and thought leaders. We have with us Richard Johnson, founder and CEO of Texture Capital, Peter Danyenko, co-founder and CEO of CoreChain, and Nate Dodson, our legal expert specializing in securities, transactional, and real estate law. And I'm Michael Carponcier, co-founder and CEO of Vest Equity. Everyone's bios and contact information will be featured at the end of the podcast and on the resources page of our website at www.vestequity.net/resources. Let's kick this off. We have lots of ground to cover. Richard, first question to you. Definition of a security. When determining whether a digital asset is a security, the SEC considers whether the asset constitutes an investment contract. As such, it must meet the three criteria of the Howey test. 1, the investment of money. 2, in a common enterprise. 3, with a reasonable expectation of profits to be derived from the efforts of others. In your opinion, do tokenized home equity investments genuinely meet the definition of a security? And should the regulators be working on a broader scope of specific definitions and rules for emerging digital assets?
Okay, thanks, Michael. So there's actually a fourth prong to the Howey test, which is, you mentioned the first three: investment of money, expectation of profits, and a common enterprise. The fourth prong is on the effort of others. And I think that's the one that's going to really come into play here. So obviously, with a home equity investment, there is an investment of money. People are investing into a contract which gives them exposure to the homeowner's underlying home equity. They're expecting profits, of course. They wouldn't be doing it otherwise. The common enterprise, I guess there's many different ways to interpret that, but you could argue that the homeowner, in fact, is involved in the common enterprise as well, because they are also invested in the equity of their home. But I think what is going to trigger a tokenized home equity investment to become a security is the investment of others. Now, if you were an individual and you were going out there and you knocked on the door of number 3 Main Street or whatever, said, I'd like to invest in your home equity, and you entered into an agreement directly with the homeowner, that would not count as a security. That would be more like a loan or some other kind of bilateral transaction. But I don't know if this is what you want me to say, but in the case of Vest Equity, it's your effort. You're the effort of others here, because you are helping people arrange these investments. You're sourcing the different homes and so forth. You have lawyers helping you structure the agreements, and you may or may not be fractionalizing the investments as well when you put them onto your marketplace. Fractionalization, in fact, was another key thing that the SEC brought up in other cases, specifically with regards to NFTs. Now, NFTs are digital art, and I think it's difficult to say that a piece of digital art that somebody is buying is any more security than a piece of, than a Picasso on the wall or something like that. But when it becomes fractionalized, that means there's a structure in place to determine who owns what fraction and so forth. and that is that is kind of the triggering of it becoming a security. Um, Another thing to bear in mind is, what was the second part of your question? Should the SEC come up with better regulation or better wording or something?
Yeah, should they take a look at something like, if we look at a tokenized real estate asset and maybe come up with a variety of different definitions for these new digital assets, these new digital secure what would essentially be digital securities. Because when
Yeah.
they designed this test, it was really for shares in a company. And now things have altered and changed where we're fractionalizing, digitizing other asset types.
Yeah.
So do you think the SEC could maybe come up with a new stream of definitions, modernize the rules so they're better adapted to today's reality?
Yeah. By the way, I should have said this at the beginning. I am not a lawyer. I am I operate in the securities business, and I we help people do
Yeah.
security token offerings or other types of securities offerings. So I'm exposed to a lot, but don't take this as legal advice. Nate is a lawyer, I believe, so I'm sure he's going to chime in after
Who's going
this.
to jump
So the
in?
second part of the question, to talk about the second part of the question, there's another legal test out there called the Reeves test, which isn't talked about so much.
Yeah.
That is basically, that has two prongs to it. One is the family resemblance, which is a strange term, but kind of, does this investment contract look like other investment contracts that are out there, stocks, equities, bonds, and so forth? And the horizontal common enterprise test, which is it's kind of like the common enterprise, I suppose, whether the fortunes of the investor are tied in with the issuer, as it were. So
Yeah.
now, could we do better than these two tests that are out there? Most probably. The Howey test, for example, was based off a Supreme Court case from 1946, or about then, a very long time ago anyway. And the world has changed a lot since then. I think when it comes to digital assets, there are a lot of rules that could do with updating. The SEC has said consistently, under the current chairman Gensler, that we don't need new regulations and so forth. We just need to follow the existing regulations. I mean, nobody really believes that. I don't think nobody in the real world really believes that. And until recently, you kind of had to go along with that. But some folks, maybe we'll get into this later, some folks have brought lawsuits against the SEC, and you can look at what the judge is saying, multiple lawsuits around this topic of digital assets and are the existing regulations suitable. And you can tell that, put it this way, the judges are either ruling against the SEC or at least commenting that the rules are very difficult to understand. I think there's a clear need for some better regulatory clarity here.
Yeah, and hopefully they will. I found it interesting what you said, though, that derived from the efforts of others. It's not just derived from the efforts necessarily of people running a company, but it could be, in our case, as an example, derived from our efforts to bring the investment to the public and then the participation of those various investors into that asset class. So it was interesting that you
Yeah.
mentioned that because I'd never looked at it that way. Anyone else have any comments on that? Nate, you're the lawyer in the group. What do you think?
I got a couple of huge comments for this, and I'd like to talk about another case that may not directly define a security, and the Howey test is absolutely the most traditional definition or test, but life partners. And the SEC brought a lawsuit against life partners, and it was actually quite a long time ago. Life partners, they fractionalized life insurance policies, chopped them up, sold them to investors, and they were out of it. Their only activity was administratively making sure that the premiums were paid. SEC took them to court, and they lost. Didn't meet the Howey test. Took them to court again in a different jurisdiction, lost. This kept up until eventually they took the same case over and over and over. They took it to court in Texas. The judge in Texas said, kind of along the family resemblance, but the family resemblance was there was a contribution of money with an expectation of profits, not from any activities of the passive investors. We can call it the close enough test. Sounds horrible because it lost over and over and over and over, but all it took is the SEC was really, their goal was to prove that this was an investment, a security, and they had jurisdictional control over it. I see a lot of these same concerns coming up with tokens, with cryptocurrency, with Ripple. The SEC, it doesn't fit exactly the Howey test, but it doesn't change the fact that the SEC wants jurisdiction over it. And if it's not the SEC, it'll be I don't remember who regulates the commodities. But at the end of the day, yep, it's still a little wild, wild west, but there's going to be more regulations. Whether or not the definition or the test of a security is updated or not, it's just a matter of time.
Yeah. Peter, any comments on that?
Yeah, the only comment I have on that is, and you said there's going to be more regulations. I think we all agree. Nobody likes the regulations until we're affected where there's an environment with lack of regulations.
Yeah.
I mean, when we look at the FTXs of the world, we look at the ICO world, we look at the Bitcoin world, nobody's questioning we need regulations. I guess that key component, and this whole conversation is about tokenization and real estate and all of those things. So I think we're going to dive into the definition. But they exist. And there's some really great framework in the real estate marketplace to work within the existing regulations. The fact that we often want to push the envelope outside the boundaries, well, businesses can make a decision today. Do I want to transact today, or do I want to make a statement for the future? So that's the only comment I have in that regard.
Yeah.
I'd like to bring up something else, if you don't mind, just because I've dealt with this quite a few times, and it is the people that put together the investment contracts. And maybe the investment contract is only with one party contributing funds, and that one investment contract would not qualify as a security. But when their entire business model is to issue these investment contracts, that is the efforts that can be the efforts of others, even if it's not. And this wasn't brought up as one of the prongs of the Howey test, but it is one of those, the pooling of investor funds. And the SEC will tend to look at the different various levels to decide if there has been a concerted effort to create an investment contract that is offered to passive people, for passive investors, for their intended profit from the gains. And I could see if they applied the investment agreement type analysis, that a lot of the NFTs as well as tokens, where you have the effort of whoever is putting together the opportunity at the top end, selling the tokens, which could be synonymous with a investment contract, could still fall under not exactly Howey, but that's how the SEC is treating it a little bit differently in the real world.
Yeah, it's an interesting conundrum. And also, the effort of others. Is that 2 people, 3 people? What do they mean by that? Is that, I always interpret it as the people running the company, the effort of others, because let's face it, you're running a company, you're running an enterprise, you can have a bunch of idiotic managers in the company and they run the company into the ground. That's the effort of others. The investors really didn't have any control over it from that perspective, so would they be defined as others? But it's an interesting way of looking at it. And my personal opinion is we are a security because exactly what Richard said. We are putting the contracts together. We are reaching out to people. It is the effort of others. And I feel we should be regulatory compliant. It's just a question of, are the rules and regulations overly bureaucratic? Can they simplify them? Can they get together with the industry and come up with better rules for the variety of digital assets that are out there? Because they're not all quite the same, right? Our asset and our investment isn't exactly like a share in a company. There's less risk. There's an underlying asset. Someone's not going to tweet the next morning. We're not going to have Elon Musk tweet about a house in Texas and the house price is going to drop off dramatically. So there are differences, and I think the SEC does need to recognize those differences. But I firmly believe regulations are important because they do protect investors. And then you look at FTX. Was FTX the result of a lack of regulation or just no oversight? When someone wants to commit fraud, I don't think they really care about regulations. They're going to damn their torpedoes full steam ahead and go ahead and create whatever criminal activity they want to create. But
Exactly.
Interesting issues I think that the SEC has to definitely look at resolving. So Peter, on to you. Next question. Regulatory reporting, which ties into some of this conversation. What reporting requirements should be required by those involved in the issuance, trading, and custody of digital assets to ensure transparency and facilitate regulatory oversight?
Okay, you said should. Well, I like to take a step backwards and say
Yeah.
the reporting requirements already exist.
Yeah.
Okay. I live in the world of tokenized digital assets in the form of securities, period, all day long. I've personally been involved in over 100 digital security offerings. Tokens. We don't even talk about this world of tokens. Okay. What's the important thing is to say, if we're dealing with securities, and the first question everybody should ask is, who is your intended audience of investors? And start with the regulations. And I think Nate, from a legal perspective, may chime in after this, but who's the intended audience? What regulation do I want to use? So to your question of reporting requirements, the regulations already have reporting requirements. The problem that a lot of companies have is they say, I want to use a regulation CF and raise up to $5 million, or regulation A exemption, A plus exemption, raise up to $75 million. You use a Reg D, 506C regulation, raise unlimited amounts of money. Each of those regulations have significant reporting requirements at the pre-raise, during the raise, and post-raise. And they change based on the underlying contracts and or the regulation. So if we know that the reporting requirements already exist, and we ask the question, how much money do I want to raise? Do I want to take the opportunity for general solicitation to the public? This is the beautiful thing about the regulations. So they're already there. The problem is, I guess, to the question of, do I agree or not agree with the reporting requirements? They exist. The problem is that people just assume that somebody's doing something with regulation A, B, or C. They assume that because tokens are being produced in a foreign jurisdiction or a different country, that a token actually means something. So when it gets to the reporting requirements, I think individuals have to take a look at, okay, from the issuance, what do I need to do? From the legal structure of that contract at the issuance, what do I want to do? From a trading perspective, what are the reporting mechanisms? So the world that I live into, we track all of this. This is what I have to do. So, but we work with independent, trusted intermediaries. So when we talk about at the filing side, I've got a digital contract. How does that digital securities contract? This is Nate coming into the picture. That contract needs to be structured so that it's easy, efficient, and cost effective for investors to click on a bunch of buttons and make an investment. From a compliance perspective, this is where, and this is back to the reporting side of it. Compliance perspective, Richard and team, the broker dealer must perform a specific task from a compliance perspective. They need a central location to do that. The beauty of this podcast about blockchain, the beauty of a blockchain, though, is we can tie all these things together. But not all blockchains are created equal, and not all blockchains are designed for every purpose. They're designed for the unique, tasks and purposes that we have. So when we're looking at this from a reporting, the reporting exists between trusted, regulated entities that are all unified in my world, it's a permission blockchain. We can discuss permission and non-permission later on. But to your question of from the issuance side of it to the custody side of it, there's rules and reporting at each stage. And each regulation has slightly different reporting mechanisms. Reg A plus, I need a transfer agent. A regulation CF, I don't need a transfer agent until I hit certain thresholds, or a custodian. So the problem with the concept of tokenizing real estate or tokenizing anything, and we're speaking of the securities world, is not understanding what that means between regulations. And a lot of individuals and companies, they take pieces of what they want to hear, and they don't have to. If they understand the regs first, you can transact. If you want to just, again, make a statement and just say, I want to tokenize this, and I don't like what the SEC is doing, or I don't like what FINRA is doing, or I don't like what the banking rails are doing, fine, don't transact. You can go and have lawsuits of millions of dollars. You can transact today under the current regulations, whether you like them or not. Just understand them first and put together your team to do so.
Yeah, those companies, in my opinion, that are thinking they're making a statement or making a statement out of ignorance, they could face some serious consequences. And I think a lot of them don't realize it. Either they're ignorant of the laws, or they think they're above the laws, or they're coming up with some exotic blockchain solution they think that doesn't necessarily define it as a security for whatever reason they make that decision. But based on what I just heard, what you guys said about the effort of others, there are certain companies I know of that think they're skirting that by saying they're sort of circumventing the rules by creating a DAO, and it's not the efforts of others, it's the DAO that's doing it, which is, in my opinion, an exotic blockchain solution that's just simply trying to skirt the regulatory issues, and you're not going to get away from the regulatory reporting or required regulatory reporting for what you're doing, and it's not going to work, in my opinion. Nate,
Well, I think a fundamental question I want to ask Nate and Richard on this is, what are you really trying to do? I'm trying to raise capital or do a transaction, and I want to use blockchain and / tokenize an asset or tokenize a security for the ability to lower my costs and have less friction and have greater transparency. So when we talk about skirting the issue, my first question is why, if you don't have to.
Yeah.
If you follow the guidelines and the rules and everybody's protected, you can run a functional operational business at a profit, or hopefully a profit. But if you want to skirt it all, if you want to just say, hey, I want to work on I'm going to create a blockchain or a DAO, and I'm going to have it housed in Liechtenstein, and I'm transacting in the United States, they're doing it over there. That's, as a technology provider, this is probably, not to go on a rant, was probably the most challenging thing that I see every day and I face. Somebody says, I've tokenized my asset. Peter, I now need to work with you because I need a digital securities transfer agent, for example. And I said, you don't understand. Why? Who got you to tokenize an asset, break it up into pieces, create a smart contract, and only not transact? Well, these guys, it's a technology provider, but they're not basing it on the regulations. They're basing it on, tech guys can do whatever they want to do. It doesn't mean you can transact. And I think to the audience here, everybody has to just understand the regulations, understand your audience, and start from there. Don't just think, let's tokenize this and make up our own rules and world because we like it. We all like this beautiful idea of independent sovereignty where I can control everything in my domain until somebody infringes on my domain. Then I'm going to run to somebody and say, hey, who's protecting me?
Yeah.
So, we have to be pragmatists as individuals too and say, I want to transact, I want to be protected, and I want to lower costs. And that's what blockchain's meant to be. Take out the friction, include transparency, and lower costs.
Exactly.
I've gone through probably 100 consultations with people that I have this token that I'm issuing, or this, blockchain, crypto, smart contract, throw it into a whole bunch of different things, but they always deny that it's a security. And I think at the end of the day, whether or not it's a security is what people don't really understand. And it is one of the most important things as well. And what I propose to everybody that's listening, as well as a panelist, is if that token represents a share or an interest in something, in an activity, in anything that's going on, and people are trying to make money off it, then it needs to abide by the securities regulations. Now, the other side of the coin, Bitcoin, there's literally no activity. There's utilization there's value intrinsic to the token, to the crypto itself. And so there is a differentiation that has gone through the SEC reviews, and they absolutely, the regulators treat differently a cryptocurrency that has utility in and of itself versus a token, a smart contract, or other types of representative interests that the backing, there is actually some other activity, people, or platforms behind it.
That's a great segue into your next question, Nate. Digital asset ownership. What legal mechanisms and safeguards should be in place to clearly establish and protect ownership rights of digital real-world assets? And how can these mechanisms be enforced across different regulatory bodies? The CFTC, which is the commodities guys, versus the SEC versus FINRA. We've got three regulators out there. They got to get their act together and work collaboratively, or else we're going to have a lot of confusion in the marketplace.
I couldn't agree more, but the way that I really see the tokens and the blockchain is in direct competition with the stock market. It is an alternative trading platform in every stock market, commodities market. All of those are regulated, and there's a lot of rules in who can hold those interests, how they get held. And so I'm actually a huge fan of the tokenizations as a platform being regulated, just like the stock market is. Maybe to a lesser extent, because there's maybe a platform with one, two, I know Peter's got 100 different blockchain investments he's worked with, 100 plus. That gets to be a sizable platform that all of these are transacting. So I absolutely think that from the platforms themselves to how the interests are held should be better regulated.
Yeah, and should crypto exchanges allow other assets onto their exchanges? Because if crypto falls under the CFTC, which is where it seems to be going, because it's not a security, but some of these other digital assets could be defined as a security. Should these all be trading on a similar platform, or should there be a line drawn and say, no, if you're cryptocurrency, you're only on this exchange. If you're a digital asset, you have to be on these exchanges.
All I can say is as long as they don't create the FINRA of crypto assets, they are not the regulators. They are a self-regulating body of members
Yeah.
that have no oversight or impact on the government or on regulations other than to its members. And it gets to be relatively difficult to deal with them sometimes. I'm sure Richard will speak to that enormously.
I'm actually not going to go anywhere near that. I have a lot of other things to say, however. Digital asset protections. So you mentioned digital asset protection. Let me start there. So obviously there are a lot of headlines around, this protocol got hacked and the wallets were drained and so forth and things like that. So there are built-in inherent protections around securities. The first one being is that a security cannot be a bearer asset. A bearer asset means basically whoever owns it, whoever has the record of it owns it. Fun fact, like in Die Hard, that's what the guys were trying to steal, was bearer bonds.
Bearer bonds,
yeah, exactly. Securities can't be bearer assets anymore. Crypto is a bearer asset. That's why you have all these kind of different threat dynamics. If you steal the Bitcoin, you can kind of get away with it. Ransomware uses Bitcoin and so forth because they can put it in a washer and then they've got it and they've got the money. You haven't, by existing regulations require that there's a transfer agent involved in all securities transactions. That's why we work with CoreConnex extensively. They are the transfer agent. So the transfer agent, number one, maintains the official record of ownership, so that somebody else may be able to hack the wallet and get the coins, but we can still go back to the transfer agent and say, no, they're not your coins. You didn't buy them. There's no record of this, etc. The other protection we have in place is the smart contract itself. So crypto assets that are kind of their own native token to a blockchain, or they can be some kind of a ERC20-like token. In the crypto space, you're using very specific smart contracts that are designed for securities, such as ERC 1404 or 1400. I think it's 3567, the other one. And these have rules in it that you cannot, the asset cannot be transferred to a non-whitelisted wallet. And a wallet can only be whitelisted if someone has gone through KYC and AML, and we know that they're not, Iranian terrorists or whatever it is. And it also has controls around the sheetment. A sheetment is a weird rule that allows, Peter can probably talk more about this, but that allows the pullback, the clawback of the assets in the case of some legal rules, such as a divorce, for example, and so forth. And then another thing you mentioned was, so we have those protections in place. Investors out there, if they're listening to this podcast and if that's one of their concerns about getting into the crypto asset space, into the crypto security space, and having tokenized securities, is that, what if my wallet gets hacked? They do not need to worry about that. The threat risk is much lower than it is for traditional crypto assets, and there are protections in place. The other question you kind of brought up there, Michael, was what about should securities be trading on crypto exchanges? Well, I think many of them would like to do that. But they can't because they don't have the correct licenses. what you need to do in order to trade a security, you need to either be an exchange, which is registered with the SEC, and then there's a very high burden. There are none approved right now at all. The Boston Security Token Exchange tried to do it; they got rejected. There's a couple of others trying to do it. It's very hard to do that because of the existing market structure around traditional exchanges. In fact, it's an interesting fact. So one of the reasons that the Boston Security Token Exchange did not get approved was because there's a rule saying that to promote healthy markets, exchanges need to be able to route orders to each other. And if only one exchange was on blockchain and the other 12 or 13 aren't on blockchain, then they're just incompatible. So that's one of the reasons that one got rejected there. Which is why we chose, when we wanted to launch an electronic trading platform for the trading of digital securities or tokenized securities, we went down the other route, which is to launch an alternative trading system. An alternative trading system is regulated under the Exchange Act, and you have to be a broker-dealer. And yes, FINRA is our regulatory authority there, and they make sure we're doing everything. But we're also at the same time regulated by the SEC. So at this point, you can only trade digital securities or tokenized securities on ATSs like Textures.
Excellent. That's a good point. A lot of people don't realize that. So that was actually...
If I can make a comment, because we're talking about this whole concept of exchanges. If you look at the difference between a bearer instrument, like a Bitcoin, and it's an easy transaction, to be honest with you. An easy transaction from the sense of I've got this unique immutable ledger that I own this particular coin. When you get into the securities world, there's a lot of intermediaries that are interconnected. You've got the lawyer that starts, he creates this digital security, this asset. You've got various signatories specific to that asset. Then you've got third-party holders of that asset, being the book of records, being a transfer agent or a custodian. So the minute you take that asset and say, I want to put it on an exchange, you now have to connect from a tech perspective to all of these other potential participants that might have been, they were instrumental in either during the raise or post-raise. And then we throw in the banks. And then we throw in the payment rails. So if you really look at a digital security today, and this is the beauty of blockchain and the concept of tokenization, is I can have all these intermediaries interconnected so that we can transact and we can hopefully lower the costs and have transparency and trust to all the participants. The problem with that is I've got all of these intermediaries all interconnected to this particular smart contract. So somebody just builds an exchange and says, oh, take this here, but when a transaction occurs here, it's going to have an effect on, let's say, the book of records over here, being a transfer agent, for example. So that's the disconnect, or the concept that Richard alluded to about of wallets. Again, without exaggeration, and this is kind of forewarning to those companies out there, companies have spent hundreds of thousands of dollars only to not transact. I built a platform, I've tokenized this. They'll come to us, they'll say, oh, we've decided it's a security. I want to use a Reg A regulation. I need a transfer agent. Peter, I need to plug in to yours or someone else's digital securities transfer agent. Because I live in the world of a permissioned blockchain with trusted intermediaries, I have the efficiencies, but on the flip side of that, I can't just say, okay, wait a minute here. You've got this token, it's in Peter's wallet. Peter wants to now tie together and raise capital, but no one's responsible for holding that instrument. No one except for the individual. So there's just a huge disconnect without going down the rabbit hole on this. Lots of different parties interconnected.
Awesome points. So onto our next question, which sort of ties in a little into what we just discussed, market surveillance. What regulatory measures can be implemented to enhance market surveillance and blockchain ecosystems and detect and prevent market manipulation or insider trading involving digital assets? I won't say who inspired this question, but a big company called FTX might have. Richard, what do you think?
I think, again, I'd kind of clarify the difference between digital assets being crypto, Bitcoin, et cetera, versus digital securities or tokenized securities.
I'm sort of throwing everything into the pot here.
So market manipulation was one of the main reasons that the SEC rejected, or the main excuse the SEC kept rejecting the Bitcoin ETFs, was
Yeah.
that they were concerned that there was market manipulation. They would point to things like Sam Bankman-Fried and say, look what's going on in the market. We can't let investors
Yeah.
get into this inefficient market. They solved that problem by entering a little bit of a circular solution, I suppose, by entering into a surveillance agreement with some of the futures exchanges that were trading the Bitcoin futures. And also, I think there's an analysis done showing that in general, that retail investors can get, there's a good correlation between the fair prices in the market and the underlying index products. I think there's a lot we can do around market surveillance in the tokenized asset space, and I'm going to go very broad here. We've got existing market surveillance tools I'm talking about regular equity markets, because that's why I'm focused on traditional securities here, equities, bonds, real estate, stuff like that. There's already surveillance tools and rules out there. And I think we can leverage a lot of those in the space. But there's an extra one we can bring to the table, and that is blockchain. There's a real opportunity here for regulators to get a kind of a bird's eye view of what is going on in markets. Because if the transactions are occurring on the blockchain, they could operate a node or access the data in real time to monitor what's going on, which is an improvement over the existing systems where we have to write end-of-day reports to Trace or the ORF, which is the OTC reporting facility, or the CAT, which is a ultimately doomed project that tried to a consolidated audit trail that came about because they were going back a little bit there. And there was a flash crash back in 2010 when the markets just dropped for some reason and nobody knew why. And they had to kind of reconstruct what happened. Having a blockchain, and we're a long way away from this, but I think it's one of the potential things that we should look for. How can we use blockchain, which is a source of truth? It's a distributed ledger that everyone has access to improve the market surveillance function.
Yeah, it definitely creates a greater level of transparency, much better than what we have today. Yeah, no, I agree. Anyone else want to pipe in on that?
Yeah, I'm going to jump in and kind of wave a flag when we talk about this concept of permission versus permissionless when it comes to blockchains and permissionless blockchains on bearer instruments like Bitcoin or an Ethereum utility. That's a different world in essence. But when you get into a permission environment you're in the securities world, for blockchain to be efficient and to the point of third-party intermediaries having access to information quickly, we do that today, and a lot of people might not be aware of it. So under the regulations, and I say we collectively, the industry that's in this digital securities and tokenization world, but you can't do it without a permission world, and I'll explain why. So in the case of Core Chain and Core Connects, in the world that I live in, so I need the regulations say I need, for example, FINRA, the broker-dealers, a trusted participant. The broker-dealer is performing a function. FINRA, their regulatory body, needs access to information. To Richard's point earlier, access to that information was so onerous in the past, but now we get audited all the time. FINRA says, hey, broker-dealer A needs the fifth email that was sent out specific to say that individual, based on whatever that exemption or that regulation was, that they had the opportunity to change their mind, for example. That's extremely onerous if you try to do this outside of an ecosystem and utilizing tech utilizing frameworks such as blockchain. But it gives third party the ability to do things, access information, get it quickly. If it's not an interconnected ecosystem, it all falls apart. And that's where the problems are going to expand when companies say, I'm going to build this, I'm going to do my token, I'm going to do my DAO, and somebody says, you're a security, give me this bit of information. Well, how do I give you that information?
Yeah.
And so trusted participants must be interconnected. And I think the other thing that companies need to really realize is, when do you cross the line if you are getting out of your lane? Look, Richard's a broker-dealer. He's a licensed ATS. Nate happens to be a lawyer. We're a technology platform provider. The moment, and this is our philosophical belief, the moment I suddenly become a broker and a tech partner, a technology company, when do I start to have a conflict of interest? Unfortunately, we saw this the other day with Carta. I'm going to be an ATS. I'm also the book of records over here. Geez, this department needs a little bit of push, from a
Yeah.
revenue, and conflict of interest comes into play. We're all human beings, we
Yeah.
may do things one day that we wouldn't do the other day. But if we take away that opportunity to run afoul or lose trust of any of the participants, whether it's the investor, whether it's the issuer in the securities world, then it all starts to fall apart.
Yeah.
So I think to the audience here, really look at what am I trying to do and what partners do I want? Recognize there's rules and put together your teams accordingly. Don't just take one isolated piece of it and say, my broker said this, my lawyer just said this, my tech guy just said this. They all have to coexist.
Yeah, no, it's a very, very good point. And having your own internal governance certainly is necessary too, and making sure your team's not going out there, not necessarily breaking any regulations, but certainly breaking client trust in the case of Carta, and throwing common sense out the window. But that interconnectivity issue you brought up is critical, and I think that we all have to keep that in mind. It's very true.
And I think the rules of interconnectivity, and here's something that people may not realize that. So when a broker dealer is doing compliance, and I think we're going to have a conversation on this later. A broker dealer is doing compliance on a tech platform. That information that broker gets as a trusted authority, it's the broker dealer's access to that information. As a tech provider, I can't access that information. As the credit card processor that's integrated to a platform, there's certain proprietary personal information that different participants cannot access. And that's a really, really critical component to maintain trust between both the investors and the issuers. Who can access what information in an ecosystem?
Excellent. Well, that could be a good segue into your next question, Peter. Cybersecurity standards. So, what specific cybersecurity standards and best practices should be implemented to safeguard digital assets on blockchain, and how can these standards evolve alongside emerging cyber threats?
Oh, okay. So this is a little broader than my tech acumen. We have a 60-man team, and there are a lot of technical guys, and I'm on the biz dev side of it. So, cybersecurity, when it comes to standards and best practices, they need to be, I guess, systematic. I mean, blockchain's ever changing. I mean, there's community groups from a monitoring perspective, continuous monitoring, detect security event. You want to detect the security events in real time, as far as hacks and things like that go.
Yeah.
But part of the equation, I think, would be who are your tech partners in an infrastructure from a tech perspective. So what I mean by that is, we live in a decentralized blockchain, but it's a permissionless, a permission environment. AWS, in my world, whether it's AWS, whether it's Microsoft, whether it's Oracle, AWS just happens to houses the servers that our infrastructure operates over. So they're regulated by the SEC. So from a cybersecurity perspective, companies have to look at, hey, Peter, just don't have your own personal server in the back room and you're going to be running digital securities on somebody's behalf. So companies have to look at who your partners are, and hopefully that they're adhering to the highest level of cybersecurity risk. So the bigger the player, the more, look, anybody gets hacked. We see it all the time. Banks get hacked, platforms get hacked. But from a cybersecurity, so the partnerships that you use and what's your infrastructure operating on, and the partners that issuers work with, that becomes really key. So you want to be looking at that. When it comes to cybersecurity, at the end of the day, it's all about personal information, right? That's what we're all concerned about as far as what gets hacked. In this permission world that I keep referring to that I live in, if only trusted participant can access specific information, hopefully you mitigate some of the risk of what information gets out there. For example, a broker dealer doing, ID verification, anti-money laundering checks, They may be using technology to give them the details of the information that approved or disproved that individual, but they're a trusted, regulated entity looking at that information to allow that investor to make that investment. Tech is going to speed up the process, but not everybody in the ecosystem, again, for example, can see that. So from a cybersecurity perspective, it becomes really, really critical to say, hey, wait a sec, Richard gets to see the fact that Peter didn't pass the OFAC test, or he's on an anti-money watch list.
Yeah.
Well, that doesn't mean everybody else gets to see it, you know?
Yeah.
So from a cybersecurity, it comes into, defining access to what information that individuals have. When it comes to reporting, for example, access to cap tables, access to digital securities. That becomes okay. One is from a tech and a hack perspective, where the information is being hosted, but it's the human side of it. In the case of that was aforementioned, to say, if I had access to that information, and I'm tempted because my sales department wants to, access new issuers. I have to make sure that I have a Chinese wall within an organization, and that's where trust comes into play. So I think cybersecurity really comes down to both from a technical perspective as well as from a technical and monitoring perspective, but also from a human level. And again, mitigate the risk of who can see what information, whether those are internal stakeholders or external intermediary stakeholders.
Yeah, it's a good point, because people run around with this attitude of blockchain because the transactions are often immutable, everything's transparent, that it's not hackable or can't be threatened from external sources. But you're right, it can be, and it does boil down to people. As we saw with FTX, it was a hack in the FTX ecosystem right before the whole thing collapsed and money disappeared. I don't think they've even found that money yet. God knows where it went, but it was a human that definitely did it.
Well, we talk about a mutable ledger. That's really, really nice. I can trace it and track it, but then I'm going to say, who's going to trace it and track it?
Exactly.
So immediately when a broker-dealer gets a request for information, that broker-dealer has instant access to it. When you've got an environment that everybody runs to the SEC when everything falls apart, but they complain to the SEC when the SEC sets rules and regulations that might be a little bit, or it can be overbroad or overreaching. I'm not questioning that.
Yeah.
But you can't have it both ways. That's how I look at it.
Yeah, you gotta strike a balance, right? And hopefully technology can play a role in striking that balance, and making things easier, and making the reporting and all those elements a lot easier. Sure. Which ties into the next part of the question for Nate. Smart contracts. They're a big part of blockchain, a massive part of it. They're sort of like the nervous system of the ecosystem. So with the increasing use of smart contracts on blockchain platforms, what legal challenges and considerations should be addressed to ensure the enforceability and validity of these contracts in the traditional legal system? So into the real world now. Got this blockchain contract. How are you going to enforce it in the legal world if there's problems?
At the end of the day, we're still in the same environment that we've always been in. People breach contracts.
Yeah.
And there's an entire judicial system that people should be able to take to approach, to deal with. I don't think it's, in a lot of them, they do have jurisdictional requirements of, if you have an issue, here's where you have to bring a court case. I would be of the opinion of, anybody that buys a smart contract, they have a right to bring their action for breach of contract in whatever jurisdiction that they're in, given that it was transacted in their state, in their county. But I absolutely think that we already have the regulations. We already have the structure. It's just a matter of looking at these smart contracts or the tokens for what they are. A smart contract is still a contract. A token represents something else. If we want to talk about safety of the overall system, regulatorily, what should happen? Well, everybody should just work with Peter. I jest, but with Core Connects, with licensed, registered transfer agents, to make sure that if oversight becomes necessity, that there is some licensed organization or company that is in the middle of things. But when it comes to a breach of contract, we've already got the system all set up.
Thank you for that, by the way, Nate. I appreciate that shout out.
You got it.
So
I think
yeah,
if we're the smart contract is an important point. We do have the transfer agents in there as well, but I think from an investor and a marketing point of view, if we are talking to investors about the benefits of tokenization and we need to get down to the smart contract level, then I think we've already lost. I think we should be focusing on what benefits it's bringing. This is a new technology that firms like Texture is a specialist in, Vestor is a specialist in, and CoreConnex is. And we're delivering these benefits, these products, and this is how they're going to work. And it shouldn't be up to, investors shouldn't be looking at we shouldn't make them try to understand the difference between an ERC 20 and an ERC 1400 smart contract. Just as they don't need to know exactly how stock exchanges work or ATSs work in the current investment environment. That's all that's all I would say here. I think it is a tremendous technology, but it is complicated, and I think we need to make sure number one, it's working and it's efficient and it's delivering benefits, but also that it's seamless and almost invisible to customers. I think that's when we really start seeing transformational change.
I think you nailed it when you said the ability to have it seamless. Unfortunately, yeah, we try to overeducate, or we try to oversimplify, or we try to look at, the word token. I mean, I don't walk into my bank or my ATM machine, plug my card in and say, oh, by the way, what database are you running that on? And how is that information moving, from A to B? I think
it'd be a pretty terrible. It'd be a messy answer if you did get that information. By the way,
it would be. But I think this whole, you touched on tokenization. It's a representation. I mean, I could call it a banana. It has no inherent anything to it. The first tokens were, I think, 1991. Wrapped around for credit cards. So you had a unique identifier with that. So a token is a token is a token. People have to understand it means different things for different asset classes. And when we're talking digital securities, it's just the ability to be more efficient and hopefully lower the costs, bring together all the participants and intermediaries that need to touch it. And that's all it is. I want to buy something. I may not like the fact that I've got to give my social security number or give my ID when I'm buying a security. And I think this is where a lot of companies want to get around it. They think, let me make it simpler. Let me pretend it's e-commerce. I'm buying a pair of shoes. But if we make it reflective to something like, I go into my bank and say, hey, I want to open up a bank account and not give them any identification, but I want to use the banking facility for other purposes. Well, they're going to laugh at me. Peter, I need your driver's license. I need your passport. I need some information about you. Same thing in the securities. And I think that's the education that both the investor community and understand the value of compliance, understand the value of really good securities attorneys. And I mean this complimentary to Nate, because you live in the blockchain world. You live in this every day. And to Richard at the same time, and to Michael, because collectively, everybody's saying, we want to do it right. We want to take away the friction. And unfortunately, the bad actors that exist out there, or just kind of skirt the law, they're going to tar and feather, and the industry at large, the securities, the tokenization, the fractionalization of real estate. And people are going to have bad experiences. And that's what's going to slow what will be, I think, one of the most significant growth sectors is the securitization of real estate that we're ever going to see. But it's going to go through a lot of bumps without people wanting to do it from a regulatory framework and a compliant framework. And don't try to push the envelope. You can push it enough and lobby the SEC to look at the rules and look at the regulations, but don't just do it and then try to transact and then worry about the consequences later, because it's going to hurt everybody involved in the space.
Yeah, it's a very, very serious point when you think, people think they can go out and not follow the rules when the rules aren't that complicated. Like, I don't even understand why some people think KYC, AML is not important. Well, it's very important, because you could have drug traffickers, you could have human traffickers, you could have terrorists. We want to make sure those people aren't benefiting from using these digital assets, making money off of them, and trying to remain anonymous and committing horrendous crimes against humanity. So it's fundamental to the success of this whole ecosystem that we follow rules. Yeah, we can push back on those rules, but we need to follow those rules because they're there for a reason. Anyone else want to jump in on that issue? We move on to our next question. Richard, back to you. So incident response ties in a bit to cybersecurity issues, but given the potential for security breaches in blockchain systems, what regulatory guidelines should be in place to standardize response procedures to protect both businesses and individuals? I think we've probably seen a lack of consistency in terms of response procedures from the regulators. So what do you think should be done to standardize that?
Well, I think I'm going to go back to what we've been talking about before. There are systems in place that protect investors already, such as the use of transfer agents.
Yeah.
What was the bit about your question about how the response times from the regulators, or?
Yeah. So given the potential for security breaches in blockchain systems, what regulatory guidelines should be in place to standardize response procedures to protect both businesses and individuals? It's a new asset. There's new techniques, new processes out there. People are not necessarily following the rules. So if there's breaches, what regulatory guidelines should be in place to standardize those response procedures?
Yeah, I mean, I'm not sure if I can answer that. I think we just look to what the existing regulations are around, these things happen today. I got letters from my bank that they'd had a hacking incident, and our personal is a corporate bank account, our personal, information was compromised and so forth. I think we would just need to really follow the same rules that we have right now in existing markets. I mean, that'd be my answer.
Okay, perfect. Anyone else want to pipe in on that?
I'd love to emphasize that Richard is 100% correct. If you look at it, the smart contracts, the tokens, amazing technology, but at the same time, they represent assets, stocks, interests, contracts that have been there for ever, decades, hundreds of years, centuries. And so we have a framework there, and there's bad actors. There's been bad actors. And there's no way around like getting rid of all the Enrons, and we hope that they don't come out. But the reality is these things happen. There are regulations, there are rules. And if we expect the smart contracts to abide by those same rules that everybody else that enters into a contract, an investment agreement, or a token that represents some security, some other activity, we've already got the framework. All we need to do is expect people to work within the framework that's already there.
Do you think it's because blockchain's brought in so many people that were not familiar with those frameworks where some of the confusion is coming about, where they think, or they're completely ignorant of these rules and they think the rules don't apply to them? I mean, we have seen in what was traditionally a regulated environment, a lot of people come into it that are new to it. And do you think that's probably potentially causing some issues?
As I had said a little while ago, I've gone through 100 consultations where people say it's not a security. Yeah. It's a token. It's a smart contract. Like, people really don't understand at a base level what these instruments are. And I agree with you 1,000%. The misunderstanding of what it represents, I think, is the biggest issue that people need to learn about.
Yeah, I think what you may be referring to here is that you have companies who are launching digital asset businesses, and they set up a website, they send out a white paper, and they start receiving Bitcoin or USDC or whatever into a wallet, and they start operating and doing business there, and they don't have the right systems and processes to kind of manage a proper business, especially when you're taking other people's money. Whereas you compare that to what Texture did, which is when we wanted to set up our digital asset business focused on the securities markets, we spent several months preparing documentation that, including a business plan, written supervisory procedures and all this other stuff. We submitted to FINRA, and then we had to go through a 6-month process that ended up taking 18 months because we had the word blockchain in our application. And it's a very rigorous approval process, and it's like that for a reason. You're handling people's money. you need to follow these rules, and then you introduce a new technology, and there's a whole other set of guidelines around it, which I think is still being worked out to this day. But I think what my recommendation here, to your listeners is that make sure that when you're transacting in digital assets, you're working with regulated counterparties who have the correct licenses, are regulated by a competent authority like the United States, not some island in the South Pacific or whatever it is. And that's going to mitigate a lot of these risks you're talking about.
Okay. Let's jump into data protection, Peter. So in the context of blockchain where data is immutable, how can regulations ensure the need for data protection and privacy with the transparent and audible nature of blockchain transactions?
Use a permission blockchain, for one.
Yeah.
And I mean that from a, and again, it comes back to some earlier comments. If I've got, where's the potential breakpoints, for example? So let me just walk you through a scenario that might help our listeners as well. So if I've got a myriad of participants, I've got payment rail providers, I've got broker dealers, I've got digital securities transfer agents, I've got banks, escrow providers, and all these there's 4 different independent parties here. So from a data protection standpoint, all of these individuals are part of the transaction process. So let's say a credit card provider, that data going in from a blockchain perspective, that data that's being captured, only the data from a transaction perspective for them to process, but then IDing that transaction, tagging that on a blockchain to say Peter used his credit card, and that's what a transfer agent can have. It says Peter made a credit card transaction. Here's the identifier. Peter has a unique ID and a hash, hence blockchain, specific to Peter. And it told me that I made this transaction, but I'm not keeping that data. So from a data protection perspective, the credit card providers have to be tightly aware and integrated to this. And this was a long journey of lots of kissing a lot of frogs, so to speak, when it comes to payment and gateway providers, because it's not e-commerce. So when we look at it this way and integrated with a payment gateway, and a large publicly traded company, by the way, they looked at this and said, if we're going to get into the securities business and buying securities, and I'm a credit card and an ACH processor, how do I know that this data isn't going to get lost and transacted? So it comes back down to your partners again. So in their world, it's following that transaction through unique ID, letting different participants access only the data they need to see. Again, the broker dealer sees his data. So I'm an investor and I give you my credit card and I give you my social security number and I give you all this data, and it's disseminated to different parties. It's also logged and tracked on a permission blockchain. But the rights of who can access that information is based on their ability to log in, hence permission, and see that bit of information so they can perform their task. And that goes right through to the escrow bank so funds can come back to an issuer. So if you really think about connecting all these dots, data protection is really about authorized participants, trusted participants who are regulated in their own sphere. And if they're regulated in their sphere, at least you're trying to build a cohesive, trusted environment between all the participants versus, and I see this every day, and I'll close out on an example. Somebody says, hey, I'm going to sell NFTs. I'm going to sell digital securities. I'm just going to plug into a payment rail provider. And what they don't really realize is plugging into a payment rail provider, I just talked to a sales guy and said, hey, I want to transact with credit cards. Well, we can just sign up and just do that. That doesn't mean and now I'm capturing that data. It doesn't mean to that investor that data is secure necessarily. So the comment, I guess, or to close out on this is working with strong intermediaries and participants that are accessing through these unique identifiers, hence a blockchain, and only giving them access to the information that that they're authorized, because Richard logs in, he sees information that I can't see. It's my tech, in essence.
Right.
So again, from a data protection perspective, again, it comes down to what's the underlying architecture, who are the participants that are participating, how are they connected, and where's the breakpoints? And that's the best you can do from a data access perspective is put controls in place between all the parties and make sure that they're also regulated in their own world. And if if our partners are bad actors, they don't work with us again. And
Yeah.
it's as simple as that.
I hope so, Pierre.
But that can mean a lot of different things. It doesn't mean that you're fined. Let's suppose a broker, for example, they're protecting the issuers. I mean, they're vetting in essence.
Yeah.
They're looking at the offering, especially when you're doing general solicitation to the public. Let's suppose a broker has 4 or 5 issuers that get sanctioned by the SEC for their offering. Well, where was the broker protecting them? The broker might not have broken the law. You see where I'm coming from? But they maybe weren't doing their job as trusted as they could be. And that's kind of what I'm referring to there. Again, work with trusted partners.
And also, not all data should be on the chain, right?
Well, that's the whole point. So we say the credit card, it's to say, I know that you paid with your credit card on this date, but that data specific to the credit card's not there 100%.
Yeah, exactly.
But it's allowing you to move data through a system and grab what you need to make that contract to Nate's, to the legal side. Hey, how did I know this transaction occurred? Things like e-signatures, for example. What does that really mean? Well, I need to tie all the information together. So
yeah, exactly. So Nate, cross-border transactions. So given the decentralized nature of blockchain, how can legal jurisdictions effectively manage and regulate cross-border transactions involving digital assets, especially when there are disputes, which will inevitably happen when people are originating from different countries?
I think it's interesting. Again, the framework is already in there, at least speaking from the United States perspective.
Yeah.
If you are transacting business outside of the United States, it's a securities token. It is called a Regulation S, a little bit different than a lot of the other regulations. There's still anti-fraud requirements as part of it. But at the end of the day, it is international. If any company, doesn't matter if they're in the United States or if they're offshore or international, if they're selling securities to US-based investors, the regulations and the regulatory requirements are already there. I think one of the biggest issues is people don't know offshore, internationally. They don't know the requirements in the United States. If somebody is transacting from the United States, they don't recognize it as a security in whatever foreign country. Speaking to our Canadian brethren, don't realize that there are also requirements there. So if you're selling a security, you get beyond the scope of whatever country you're in. There are those obligations, but it really falls on the issuers and the intermediaries to make sure that things are being done correctly.
Yeah. Great point there from Nate that people forget about. You can issue, a Reg S which is what in the US, the SEC cares about Americans mainly. Yeah. And then if you're issuing a private placement in the US, you'll do a Reg D offering. If you want to sell it to foreigners, you do a Reg S. And there's no, for example, with a Reg D that you need to be accredited. For the Reg S, you don't have to be accredited because they don't care as much. But what everyone forgets is that what about the regulations in the other country? And, for example, in many European countries, there is what's called there's a type of exemption where, as long as the investment amount is above a certain level, then it's exempt. So it's kind of like, if you're rich enough to put in 200,000 euros, then you're probably okay taking the risk here, kind of thing. Yeah. But you don't know. You got to know all the different regulations in each of the countries. And the fact is that it's much more difficult to transact cross-border for a security token than it is for digital asset. You can send digital assets anywhere. They are on these permissionless networks a lot of the time. A lot of people think mistakenly that that's kind of what's going to happen when we have fully tokenized capital markets. That's not the case. It's possible, but it's not going to work the same way.
Yeah, it's a great point that both of you brought up. People forget that they've got to be compliant in the country they're selling the securities into. Yeah. I've had lots of conversations when I've been in Dubai where they don't realize that they have to be compliant with U.S. regulatory laws when they're selling securities into the US. They feel they can just, as a foreign entity, just sell it to anyone that they want to. And no, you've got to be compliant. There's no way around that.
Yeah.
You've got to follow the rules of the country you're selling to. And again, as you mentioned, if you're selling from the US outside, the SEC is not concerned, but you better make sure you're following the rules of whoever you're selling into. So,
Yeah, Michael, you brought up a really good point, and this is for Richard and Nate here, I think. So when I look at a regulation, and just because tech can do something, and again, from a techie perspective, so Reg A plus, I can take investors from anywhere in the world, non-accredited. Okay, however, that's where you really need your lawyer and your broker dealer to have a consult to say, what countries do I want to take investors from? Because
yeah.
both from that jurisdiction, but also from how onerous may it be for, let's say, ID and KYC and anti-money laundering checks on an investor from Angola versus the EU, for example, or France, or even from a Canadian perspective. One day that security, I'm a Canadian. One day I can invest in company A under that Reg A, and the next day from a Ontario versus Alberta versus British Columbia, they have different provincial regulations. I said, what? Today I can't invest because the Ontario Securities Commission had indicated that we're not sure where we're going with this today. So it's absolutely critical that your broker and your legal consult, you talk to them. Don't make assumptions because you see somebody on the web doing it this way. They're doing it, and so.
So I'm gonna switch gears here a little because you brought up an interesting point about KYC AML, and I had the question in here about more related to property rights. But it's an interesting issue because if you're in a foreign country as an American entity and they want to sell into the US, or you're a US company and wants to sell into a country like in Central America or South America or Southeast Asia, how good is KYC AML vis-a-vis those markets in terms of them complying and being able
if I can weigh if I can weigh into that a little bit.
Yeah.
It's as good as the software that you're integrated with,
Yeah.
and it's going to dovetail to the broker dealer. For example, in my world, we happen to use LexisNexis to do what we call a first pass: ID, KYC, anti-money laundering, and it has to cross-reference a lot of data. There's really simple KYC platforms say, oh, as long as I got a social security number, that's a real number. This seems good. That doesn't mean it's Peter. That just means I have a social security number that's actually a valid social security number. So you need to commingle. Easy in the United States for the most part. But when you do foreign jurisdictions, this is where it comes into your broker and the tasks that they're doing. They're going to ask those individuals to, in all likelihood, because upload some personal information, photographic information, your passport, your driver's license, because your ID verification, from a tech perspective, it's just going to fail too often. It's going to say, I don't have enough data. And that's what the broker's getting paid from a compliance perspective, is to say, hey, I've got to do extra work here to confer that, do the ID and the AML. Richard, would that be?
Yeah, I mean, your KYC and AML as a bedrock. Know your customer. Number one, you got to make sure you know who you're transacting with. AML is anti-money laundering. We need to run it against various types of, obviously, terrorist watch lists and so forth. Has the person been, are they a bad actor? Are they, have they committed fraud and so forth? You want to know that before you're selling investments to them. There's a concept of PEPs, politically exposed persons, as well. This person, he's the brother of the Prime Minister of Moldova or something like that. So, well, that's, let's make a note of that. Doesn't mean they can't trade on anything, but we need to know that and consider that in the transactions that we're doing. I think there's, relatedly but separately, I think there's a opportunity around what's called digital identity, where you can create, kind of a passport that's on chain. And there's some companies doing this now that can potentially streamline the KYC process. So you kind of have this kind of passport token in your wallet. And then if you go to a permissioned DeFi protocol and you want to transact in a kind of more regulated but DeFi protocol, instead of going through the KYC process each time, you can kind of demonstrate that you've been KYC'd and that you're an accredited investor or whatever by leveraging this decentralized identity. I think that's a very powerful tool, and I think and it obviously works on blockchain. It's a blockchain product basically. I think it's a very powerful tool, and we're going to be seeing a lot more of that over the next couple of years.
Yeah, I hope we do too, because I
Yeah,
know I
it's
can't
something
stand
that,
doing KYC
yeah,
AML over and over.
Yeah.
no,
Yeah.
Plus,
You know, I'd like to
the
throw
data that's
out
out
there.
there again and again. Like, oh, look, I give them
Yeah.
my bank statements or my lawyer, whatever it is. Maybe just a letter from the CPA. You don't want that data out there. Yeah.
Yeah, and it essentially ends up being out there because you're doing it over and over and over again. If it's in one spot and you've got the
Yeah.
token, it would be a great tool. I want to definitely see that happen.
Core ID. It's something we built into our platform, and people don't understand why did you do this? And that's the whole concept, what you guys are all saying here.
Yeah.
It's a unique identifier on that individual, again, tied to a chain that says, I've already done this. But that doesn't omit the fact that, hey, I might have not been on the AML checklist this year, and I don't know what the timelines, Richard, you would know, as far as that. Again, that's where the broker comes in to say, hey, we need to update an AML check or something, whatever the parameters are for, is it annual? Is it, when I'm reinvesting, for example.
Yeah.
But yeah, take away the friction. That's where the tech is really going to come into play in the future, is to say, I'd love for it to be as seamless as a credit card transaction and give my identity, my information, but do it in a secure way. So we're not there
Yeah,
yet.
exactly. So
Everyone on this panel has KYC responsibilities to some extent from the investor side. As an attorney, I have that to a level with the issuers themselves. But I would say the biggest onerous obligation here is to Michael as the issuer. We have our liabilities if we don't do proper KYC, but at the end of the day, it really goes to the heart of the issuers. It's ultimately their responsibility to make sure that their securities are being offered correctly, that they're not going to the drug dealers, to the terrorists, to the politicians. It really, at the end of the day, is the issuer, but that's also where the issuers have to, for their own protection, work with experienced, knowledgeable team members on the technology side, on the planning side with the attorneys, as well as the sales and broker-dealer activities. It is so important, but at the end of the day, Michael, as the issuer, it really falls on your shoulders more than anybody.
Yep. That's why we take it so seriously. I don't understand people who don't.
Yeah, you
So
know what? On that, I think one of the challenges that I find that I see with issuers sometimes when they're going from one regulation to the other. So typically, companies have raised capital before. They were dealing with accredited investors only. They're doing Reg D, 506Cs or Bs, and then they're going to jump into the world of, hey, wait a sec, I can do general solicitation. I want to do a Reg CF or a Reg A. And the requirements for the data capture and the communication between the different regulations is exactly that. It's different between the regulations. Because I get clients all the time who go, I never had to do this before. Why do I have to do this? Because you're not dealing exclusively with audience A.
yeah,
You're dealing under a different exemption. And that's just the rules. And you need to communicate. So you can get the benefit of reaching out and solicit to a wide net of individuals, but you're going to have to follow some more rules and guidance. They don't like it. They just, and I think part of that's the change. Well, I don't have to do it over here, so I don't care. I get clients that go, I don't like the KYC. I'm going to move over here because it's too hard. And I'm going, it's not me. They're going, well, just make it easier, kind of thing. Or you are taking pieces of the law. A common
famous
one.
last words.
Yeah,
Make it easy.
it's being selective between the regs. I don't have to do it over here. Or FINRA said I don't have to do this here, and I go, great. FINRA said you don't have to do it over here, but your payment rail provider says you have to do it over there, or your sponsoring bank assume you're doing it. So somebody in an ecosystem may indicate to you that you can't transact in my world without doing this. So you can't be selective. You do have to look at it from a holistic approach and understand where all the participants' roles are and what they're going to ask you to do.
Exactly. So Nate, last formal question to you. Tokenized residential home equity. What are the implications for property ownership title transfer, and dispute resolution, and how can blockchain technology and legal frameworks work together to provide clarity and security for all parties involved?
Correct me if I'm wrong, but with the types of securities investments you're talking about, it is really no different than a tenancy in common agreement, where you're fractionalizing an interest that's attached to the residential property itself. And along those same lines, whether you call it a token or a smart contract, there are the obligations of the intermediaries, the homeowner who still has an interest in the property itself, but it is to some extent fractionalized through the secured interests or directly in the ownership at the end of the day. But as long as it's recognized as this is a security, there's rules and regulations behind what's being offered, and whoever is issuing the security, it's ultimately their responsibility to make sure that things are offered properly, KYC is actually done, and all parties are clearly protected, or at least to the extent of disclosures being made. I think there is a level of protection across the board as long as everybody's on the same page and there's the regulated intermediaries that are watching out for the bad actors.
Exactly. Mm-hmm. When do you think all titles will be on blockchain?
No clue.
That's
going to be a huge
when they are.
That's got to be a significant challenge. I mean, you've got jurisdictional issues, you've got bureaucratic issues. But Nate, I got a question to you on that. What is the mechanics right now today of residential real estate properties? They're registered with my title agent. Who's doing that? Who's responsible? Because that's kind of, we talk about blockchain, but that's kind of outside of it, right? Like right now, somebody has to move that information or register that particular property with my transfer agent, and we struggle with where that's going to land in the future. I mean, I'd like to have it all connected, but it's not going to happen in the immediacy at all.
Well, correct me if I'm wrong, but Michael, with your issuing investments, part of your services, the efforts of others, is going through the proper regulatory registrations, recording documentation. So at the end of the day, it may not be the property owner. Property owner may hire an attorney to assist with that. Or Michael can create a security and an investment and issue it based on his services of making sure everything is recorded, registered as necessary, promoted legally, and the blockchain is keeping up with things every step along the way.
That's exactly what we do. Exactly what we do. And that's, we view as our responsibility to make sure title's clean. Sometimes we've come across titles that aren't clean. We've helped them clean them up. This is part of our process and part of our responsibility as the issuer.
So we need to integrate with your platform, Michael, in order to make it even more seamless from A to Z, because you're...
Is this a sales pitch?
No.
ABC?
No, definitely.
It's that other pieces when people say, okay, where does it fit?
Making our back end more robust over the next several months is definitely going to be one of our priorities. So we've come to the conclusion of the formal questions. Like, we've done a great show, everyone. I really think we're seeing the start of a big shift in financial services and real world assets, and I think it's going to open up a whole world of wealth generation as we collectively work together to liberate capital and put it to work, which I think is the goal of capitalism. So what I want to do is, my favorite part of the show is, let's end with some thoughts of what lies down the road for 2024. What will be the big noteworthy developments for blockchain and real world assets in this coming year? Richard, you're first.
I think it's going to be an exciting year. We touched a little bit on Bitcoin ETFs, which got approved a couple of weeks ago. Larry Fink was the CEO is the CEO of BlackRock, and that firm, I think, was instrumental in getting everyone over the line. The world's largest asset manager, basically. He's a big blockchain proponent. He said back in March last year that he felt that the next generation of markets would be tokenization of securities. And in his speeches at Davos last week, when he was asked about the Bitcoin ETF approval, he said, maybe it wasn't at Davos, but quite in the last week or so, he said, this is just the first step. The Bitcoin ETFs are just the first step. The next step is going to be the tokenization of every financial asset. So I believe with him, and I agree with him, and I think that is going to be my prediction as well.
Yeah, I think he mentioned real estate in there too.
Yeah,
Peter?
Well, on the subject of real estate's probably I see bigger and bigger opportunities in the real estate sector. I mean, from the general public awareness to say, hey, I didn't realize that I can start investing. So I think we're starting to cross the chasm a little bit where the general public is becoming educated. And I envision a day where you could drive down the street and see a building and say, I wonder if I can buy a piece of that.
Yeah.
And if you really look at the big picture and say, oh, I can go online, I can look at a QR code and see that, hey, they're selling digital securities, or they're selling tokens in this, which underlying digital securities in this particular asset. I mean, that's the real vision. Or I'm driving by a McDonald's and I'm going, hey, can I have a piece of that McDonald's? How do I do that? I mean, that's not going to happen, this year. But if you really think about it, it wasn't that long ago, pre-COVID, that, in the public marketplace, when we looked at, what was transformational was all of a sudden Robinhood, and everybody's sitting here, all these guys are became certainly aware that, I can transact and I can trade and I can buy securities in public companies. We're a long ways off of that happening to the private world. But I think that's the future, to say, what asset class do I want to participate in? And be able to actually look around and see more of that. But I think the biggest thing this year, I think, is going to be one of, it should be, is trust. There has to be trust in the industry, and the more that we hear the media come out, with the bad actors or crossing the line and things like that, I think it benefits us. It puts the industry a step backwards sometimes, but it benefits us and creates awareness. When people look at, you look at the ICO world and you look at Bitcoin, and okay, you've got your poster childs, which are performing well. And then you got 10,000 bad actors out there. There's literally 10,000 ICOs that were created. 10,000. It's mind-boggling, and the majority of them, same in the NFT space. So I think 2024, it's going to be, continue with awareness. It's going to be a marketplace of trust. But education is absolutely critical, because people are going to trip over this word token over and over and over again.
Yeah, they definitely will. Nate?
I think the biggest impact is really actually going to be these secondary trading systems. They really haven't existed to a real extent, other than the stock markets.
Yeah.
Or unregulated, not overseen, non-permissioned. Well, it's just been within the last few years that these secondary trading systems offering the tokens, the opportunities, these private securities that otherwise people used to just buy, and they're stuck with it. There was no one else to actually acquire it, to sell it to trade on. And I think those secondary trading systems are just going to get more and more advanced. Also, as part of it, require more and more transparency of the securities issuers, so that information is fluid, so that there is the opportunity of those secondary transactions. Because right now, I don't know how well that McDonald's is doing. Should I really buy into it? Well, if that secondary platform has the reporting, and that I know, I can't wait to own a piece of that Big Mac.
Yeah, liquidity. It boils down to liquidity. You're absolutely right. Transparency and liquidity, for sure. It'll take us to the next level in the alternative platforms and secondary markets, for sure. Well, I think that's a wrap. I want to thank everyone for your time and your insights, and for participating in our podcast. And good luck to everyone for the forthcoming year. And let's hope there are big things for everyone in 2024.
Here's to 2024. Michael,
Yeah.
Thank you very much for having me.
Thank you.
Thank you, Michael.